I would like to give just a quick plug in that regards to Nick. That next month I'm actually part of the Los Angeles 3D Club, which also meets in Pasadena and meets about 2 blocks from where the library is. And that, sorry, let me mute a couple of people here. Apologize about that. And next month they're actually doing a presentation, Civil War in 3D, which we've got Bob Zeller, who is an author of a number of Civil War books from South Carolina. He's going to be doing an online presentation for that. I'll be providing the information to Janet to be able to see if we can get it on the website or possibly into the newsletter, but that's coming up next month for that. So I think it's going to be an exciting one. I've seen the presentation previously, and it's a terrific presentation.
Do you know what the date is?
Yes, I do. The presentation date will be July 16th.
Okay,
Thursday,
so we'll try
July
to make
16th.
sure it gets on the website, because that'll be right about when we mail the newsletter.
Right, right. And Mark, that your screen, we're seeing it, we're not seeing it in full screen, so I don't know if you want to be able to take that to full screen. We're just seeing it in the preview mode right now. In the lower right, down by the 118%, you've got a button there that will take it to full screen to be able to just show it there. Just to the left of the 118%. Do you see it at the bottom of your screen there? Mark? Very bottom of your screen where it says 118%, and then there's a minus sign and a plus sign in the bottom right. There's
Mark is muted.
Your other option, Mark, is to click on slideshow, and then you've got an option to be able to play it inside the slideshow at the top there.
Mark is muted.
Yeah, Mark, you need to unmute yourself too.
Sorry, I can't find any numbers that show, I'm sorry, I can't find any numbers that show the percentage. Let me
see
go
where
down
the
to
slideshow at the top? Just click on the slideshow at the top on the menu bar there. It says File, Home, Insert, Design at the very top. It says, do you see the one that says Slideshow? No, the menu, the choices. There you go. Keep going to the right where it says Slideshow.
I'm like, I see new slide layout.
No, you're in Home.
Oh,
Insert.
File.
Yeah, keep going over
Insert.
to Slideshow. No, over to Slideshow.
Sorry.
Although the top menu choice, no, you see where the top choice above that? There you go.
Okay, sorry.
And then there's one in there to be able to just view it. Do you have 2 monitors?
I do.
Oh, we're viewing your other monitor.
Okay.
We're viewing we're not viewing your presentation monitor.
Yeah. So let's go to the settings. No.
You can actually go into go to meeting, and then where you clicked on the green thing to be able to share it.
Oh, right there. Yeah.
Yeah, and then you can choose the screen you want to share.
Let's see. I'm sorry.
Not a problem. Just choose the screen where it's full screen.
I know. I don't see where to choose a screen. Let's see. I've got settings, the people.
Just click on to be able to view. No, go to do view. You should the green button to share your screen again. And when you do, then it will show you the options.
I don't know how to go back to that.
Okay. It's inside of the go to meeting setting in there.
Go to meeting settings. Yep. But I don't see the buttons anymore for myself to share.
If you move your mouse over top of go to meeting over the screen, you'll see it at the bottom in the middle of the screen there.
Right here?
I don't know. I don't see your screen.
Oh man, I am.
Okay,
I feel
let's
like
do
a
this.
judge. All the judges are doing this now.
I am clearly. I'm closing.
I'm clearly not knowing what I'm doing. I used to see where I could mute myself and where I could share my. screen and all. Okay, here we go.
Yeah,
Mike.
let me do this. I'm going to give it back to you. I just took it away just to make
Yeah.
it easier so that I
Go
can send
ahead.
it back over. So let me send it back over, and you should see it pop up. And now I see you in there twice. Let me see. Hope I hit the right one. Let's try it. Well, actually, you've got your mic unmuted, so I'm going to take that one. Let me try that one. All right, do you see the request to share your screen now?
Yeah.
Okay, go
Oh,
ahead.
okay. It was under the browser part.
Right.
How's that?
That looks great. And
Okay.
for everybody
You guys
else,
all see
if
it?
you want to make it full screen on your end, just go ahead and slide the area where the
Good.
camera's up out of the way, and then if you press F11, it will go to full screen.
If I just do tab, will it go down to the next?
You can just
Yeah,
click on
okay.
it or do tab. Yeah, there you go.
Yeah, this is fine. Hi, how's everybody doing? I really apologize for that. I feel like a judge, which I guess is a good thing because listen to all the judges deal with all the technical problems lately. I'm assuming everybody is at home, not out and about. It'd be better to. Where do you guys normally do this? At a restaurant, a bar, at a library, at a
The
Rex
Pasadena City Library.
Okay, good. Well, I hope everybody's doing well. I do not mind interruptions at all. If anybody, whatever the system is you guys have for talking, if anybody's got a question, chime in. I deal with that very well. I actually like questions. And I don't mind confrontation. If you think that I'm completely wrong on something, you probably are right. My name is Mark McGuire. I'm an attorney in San Bernardino. Did about 8 years as a project manager in a computer company after I didn't get into the graduate school for philosophy that I wanted. And then my wife's business got set up and was running very well, so I went to law school and been working in the field of probate estate litigation for about 11 years since I got out of 12 years since I got out of law school. I got roped into doing a talk in Redlands at ESRI, the company, by a young man that I know, his father, and he comes over to our house and has dinners, and we hang out and swim and play sports and stuff. And he's a little bit obsessed with the Civil War, like I was when I was younger. I grew up in a fairly large farm in Central Valley, and just to show you like how strange an obsession with the Civil War I had, I would reenact Civil War battles by myself, moving the regiments around in the field. I particularly liked Gettysburg, but there were other battles that I would reenact as well. So it becomes kind of an obsession once you get into it, as everyone in this group knows. It is very interesting, very important, and has lots and lots of angles for lots of different issues. One thing I noted, you guys probably all went and saw it a few years ago. The Huntington Library had an exhibit on the non-military casualties of the Civil War, which was one of the best things I've seen in a long time. So I try and follow things. I don't read as much as I used to because I'm a lawyer and my time is consumed by people screaming at me. But I do try and keep up with as much as I can. So what I want to talk about today is when I was talking to this young man, and I told him, well, there's this interesting case and it relates to a lot of current politics, and the law is kind of in flux regarding how to test executive powers. It's kind of evolving given the things that are coming up. And he thought, oh, that'd be really interesting. Why don't you do the talk on that? So when a young man asks you to do something, you kind of get roped into it. So I didn't want to let him down. So I did it. Apparently it was okay. I might fall on my face at this meeting. You guys probably going to make me up my game a little bit. And if you got questions or I don't explain something right or things a little wrong, just chime in and tell me. Am I to unmute people, or if anybody else wants?
I'm going to take care of that. I'm going to try to keep everybody muted so that it won't be a distraction because there's background feed of the audio. And then
Sure.
when you're done with that, I'll just go ahead and open up the mics, but I'll try to keep everybody muted just to keep the feedback out right now.
Yeah, so the way I do it is I kind of try and build a concept through things, my background being in philosophy. and law use the Socratic method a lot. So I may do that, and I may do the Socratic method and answer my own question just to make things move a little faster. But I try and make things so people can understand them, but I also like the interaction between people. So my father, being a professor and a minister, always told me, you know, when you're doing something to talk, there's the 3 basic rules are: first, you tell them what you're going to tell them, then you tell them, and then you tell them what you told them. So this is the part where I tell you what we're going to talk about. The overview is we're going to talk about the Great Writ, the writ of habeas corpus, and the suspension of that writ. There's actually 3 different times during the Civil War that the writ was suspended. This is the first time in the very beginning, and this is the one that was done by an executive order. So Congress didn't pass a law. Lincoln just issued an executive order, and I'm probably not telling you anything you don't already know, but the writ of habeas corpus is just, habeas corpus means to bring the body. It's literally what it means. So it comes from common law of England, where the executive branch of government at that time, it's the royalty, the king, the crown would sequester people, arrest them, keep them locked in the tower, and not give them access to a trial, to an attorney, to due process of any kind. So the courts created this writ process or lawsuit process where you could sue the executive branch of government essentially to force them to bring someone to court so that they can have a hearing. So we're going to talk about that. We're going to talk about the separation of powers and the discretion under the executive branch of government and their powers and the limits maybe to that discretion. The standards of review, and that's where it gets really, really wonky. And I realize that there's anyone here who's a constitutional scholar, which a lot of you probably have studied a lot of the Constitution. It's not exactly right the way I present it. I understand that. It's presented because this is kind of the way it works with the different standards of review regarding. So that's why I want to touch on that, because the standards of review is very important to understand how the court is actually looking at these issues. And on that point, I want to make sure that the things we're going to talk about have very, very deep political undertones. But when the court looks at things, at least from my perspective on the constitutional level, they're not strictly looking at the politics. Politics always comes into it, but they are first and foremost looking at the structure of the Constitution and where the powers lie and what the limits of those powers are. And then we're going to look at kind of a little bit in depth into the case of Ex parte Merriman, and then a test that came up. So we're going to bounce around in history a little bit. A test that came up after World War II is the Youngstown test, which came up in a case under President Truman. After that, we're going to look at an application of a very, very important case which just recently got overturned called the Korematsu case. When I was in law school, we were always taught the Korematsu, although badly decided, was still good law. Now we can actually say Korematsu is bad law. It is no longer good law in the United States. And it's interesting what case overturns Korematsu. Then we're going to go on and talk about a couple of the Guantanamo cases, because they involve some big law regarding limits on executive power. And then finally, the Trump travel ban case. And then I have a extra add-on just if we have time, but I didn't do a slide for it because it's a little bit of a complicated idea, but I think it's kind of a fun way to bring these concepts of limits of executive power up to the current issues regarding the protests and COVID and the issues of executive power and police authority that's going on right now. Nothing overly political. I think you'll find the idea that I have a little bit interesting, maybe a little bit fun and thought-provoking on another section of the Constitution, just as a little primer for you. It's about the Fifth Amendment and the takings clause under the Fifth Amendment. So that's where we're going. First thing is a historical perspective. Everyone here probably understands or has some basic understanding of the history of the Civil War, when it started, how it started, and the location of Washington, D.C., and the presidency and the executive branch of government during that time. Essentially, Washington, D.C. was, for all intents and purposes, surrounded, and it has a lot of rivers, lakes, and waterways, and it's protected by bridges. And the Union was attempting to mobilize the army to the south to engage the Army of Virginia, and was trying to move through the states. At this time, there was a lot of radical activity and sympathizers for the South in the border states. The border states were an area of contention. So, for instance, Maryland did not secede, but also gave orders that the Union troops were not allowed to move through Maryland, which makes it slightly difficult to get from bases in New York and New Jersey to battlefields, potential battlefields in Virginia. So there was a lot of things going on, and I'm saying this not, I understand I'm not in support of any one thing one way or the other, but there's a lot of stuff going on in the very beginning of the war. So for instance, because of these problems with Maryland, Lincoln had disbanded the city government of Baltimore and was about to disband the legislature of Maryland. And eventually he barred a bunch of the newspapers in Baltimore from publishing things. So it's kind of a war going on inside the war between Lincoln and the press, and then different branches of government. At this time, there's a lot of Confederate sympathizers, essentially terrorists, running around in West Virginia, Maryland, a few other border states. Specifically in Maryland, there was a lot of support in Baltimore. One of the men in these militias was John Merriman, who was accused of participating in some activities, stealing armaments, blowing up bridges, and Lincoln was having no part of it. And so he issued an order to arrest these people and go arrest them, and to also then suspend the writ of habeas corpus, which means lock them up and don't give them right to counsel, don't give them access to see their family, don't give them a hearing, don't let anybody know where they are, basically completely suspend due process of law. So Lincoln issues that order, and the Attorney General lays that down to the commanders in the field. So what happens is Merriman gets arrested at his house, and he has an attorney who knows that he's been arrested and knows where he is. That attorney seeks to get an order based on the writ of habeas corpus to have his client released, because his client is being deprived due process. He's not being deprived access to, he's being deprived access to an attorney, access to his family, access to any court. He hasn't had any hearing at all, and he's locked up in Fort McHenry, which is an interesting note on this, and it comes back full circle that Francis Scott Key wrote the Star Spangled Banner about the Battle of Fort McHenry, which is where Merriman is being held, and his grandson, Francis Scott Key's grandson, is a reporter, ends up writing about this very case and Merriman being held. So there's a bunch of interesting connections in history regarding this case. So the attorney for Merriman goes to DC and seeks an order from the Chief Justice of the Supreme Court, Taney, at that time, but he was also just a district judge doing a circuit. So it becomes very, very important, these minor details. And I know that people not in the law get frustrated that like these minor details in some case may turn the whole case, but they're very important. So this case may be very different if Merriman's attorney had gone through the normal processes and gone through the district court and then gone through the appellate court and then gone through the Supreme Court, but he goes straight to Chief Justice. They do give notice to the U.S. Attorney's Office, and Lincoln promptly tells his U.S. Attorney to ignore it. The attorney asks for more time to file a response, and Judge Taney denies him more time, says, no, I'm just going to rule on it. So Judge Taney issues a in-chambers order. So that becomes very important. This is not a decision that comes after a trial. So arguably, the U.S. Attorney's Office didn't have due process to defend the case. It's not a case that was presented by oral arguments in front of a panel of judges or even in front of the Supreme Court as a whole. This is an in-chambers order, basically a letter written by the Chief Justice ordering the commander of Fort McHenry to produce Merriman. So he's not giving a constitutional ruling on Lincoln's authority to suspend the writ. He's just saying, I want to see the defendant brought in front of me. So to give you some background, the writ of habeas corpus section of the Constitution is in Article 1, Section 9, and it reads in full, the privilege of the writ of habeas corpus shall not be suspended unless when, in cases of rebellion or invasion, the public safety may require it. So the question here for discussion, and I want to open it up for a little bit, is who has the authority under the Constitution to suspend the writ of habeas corpus? Does anybody want to chime in? Does the Constitution say who has the authority, and does the Constitution set up a test for when that authority, when the right to be brought to trial can be suspended by the government. So at this time, this issue hadn't been decided. This is really the first big test to this, and Lincoln issues the writ. So the Constitution does not say it's the executive branch of government. The Constitution actually says it's, well, it doesn't say who has the authority, but it's under the Article 1, which is the article for the legislative branch of government. So arguably the executive branch of government cannot issue that suspension. It would have to be based on an act of Congress, which later Congress does act to suspend the writ, but they didn't in this first instance. And this will become very important when we talk about the other cases of Youngstown, Korematsu, and some of the other executive order cases that we'll go into. So the decision by Justice Taney, I think I'm saying his name right, Taney. He is, interestingly enough, this is how politics crosses over into this. He was the judge who wrote the decision in the Dred Scott case, and everyone here who has studied or understands anything about the Civil War, how it came about, and the cases that led to it will understand what the Dred Scott case is and why there was no particular love lost between the Supreme Court, specifically Chief Justice, and President Lincoln. So that writ was issued ordering General Cadwalader of Fort McHenry to produce Merriman in court. Lincoln then promptly issues an order to the general to ignore the order. So now we have a battle, a real battle between the branches of government. Maybe the legislature's not necessarily involved at this time yet, but we certainly have a battle between the judiciary and the executive branch. And so the general ignores the order. So the next question I have for everyone is, what's the general supposed to do effectively? Does the general have the authority to ignore this order? Does the general have authority to ignore any orders from court? And in particular, did the general have the authority to ignore this particular order? What does anybody think?
Seems like because it's the president is in charge of the military. He's the commander of the military. His order would be the supreme order. Right.
He's the commander in chief of the military, and line of command would dictate that the general would have to follow his order. Does everybody agree with that? Does everybody think that that's right?
I disagree with that.
So generals don't have to obey the commands of the president?
Having been in the military, I would say that they do follow the commands of the president unless that order is deemed to be unlawful. In this case, it is unconstitutional. So technically, I think that he would not have to follow it. But we all know what actually happened, though.
Right. So it's like, I mean, again, we're having a discussion. No one's, none of us were there. We don't know exactly the motivations or what actually happened. But you're right. The general is in a difficult position here because arguably the chain of command would dictate that he would have to follow the orders of the president. However, the Chief Justice of the Supreme Court issued him to bring Merriman to court. The question I have for you is, and I think your comments, both comments are fantastic, but just to like flesh this out a little bit, was this really an order from the full Supreme Court, or did it say that Lincoln's order was unconstitutional?
Well, it was ex parte, which means one party only.
Correct. And then the other thing is, it's not the full Supreme Court, right? This is just a judge, arguably, who's got a beef to grind against Lincoln, basically writing a letter in his chambers when an attorney came to him on an ex parte motion. Now, to be fair, he denied the U.S. Attorney's Office more time to file a response, but we all know the response probably wouldn't have meant anything. But here's another little caveat to make this just a little, if you don't think it's difficult enough to understand the complexity of whether or not this order had to be followed. The order was technically never served. So who knows what's the importance of serving an order in trying to enforce it? Does anybody have an idea on that?
Well, isn't it like a subpoena?
It's very much like a subpoena.
Court orders you to do something?
Correct. So if a court in Maryland tomorrow, issued an order against Mark McGuire and never told me about it, would I have to conform to that order?
No. You have to be properly served.
Yeah, so in this case, technically this is an order from the Chief Justice to the commander of the base, and this order was never actually served. So there's kind of a gray area in the history of this. A lot of people have written about it. One story is that the process server, it was just a marshal, took it to the base and was denied access after it was communicated to the general that the marshal was there to serve. So technically, it's like sub-service. You knew about it. You just tried to evade service.
Service.
Go ahead.
Gutter service.
Yeah, so it was not technically served. The other question that's raised is even if you give the general the benefit of the doubt and say, okay, he didn't know about the order, he wasn't technically served. How did Lincoln know about the order to issue the general an order to disobey the order, right? So come on, everybody knew about this order, and there's a little bit of three blind mice going on right here where people are just trying to ignore what's going on. But the consensus is the order was not properly served, but the general knew about it. So from a lawyer standpoint and from a military standpoint, although I've never served in the military, I've worked with a lot of military people and worked on military contracts. They would take the rule of law and the intent of the law very seriously. And so the general, who probably knew about this order, just ignored it because the President of the United States basically ordered him to ignore the order. So the question I have is, how much does it matter to anyone on this panel that it was just an in-chambers order from one judge on an ex-parte hearing versus if the attorney for Merriman had gone through the whole process and ended up getting a decision from, it was 7 at that time, justices on the Supreme Court? Does that matter?
I'm going to go ahead and do an unmute for everybody else.
Go ahead.
There was no due process.
Who didn't have due process? I agree with you, but who didn't get due process?
I would say Merriman did.
Merriman.
What about the U.S. Attorney's Office?
It didn't affect it from the Supreme Court justice. And of course, he jumped over several levels of court organization. And it's a question of whether or not it was properly established to be served.
Right. So, I mean, do we think that the Chief Justice had any subjective motivations against Lincoln?
Oh yeah.
Do those matter? Do the subjective motivations of the Chief Justice matter, or are we okay with the fact that the Chief Justice was right and therefore we're okay with it?
It doesn't matter whether the Chief Justice was right. He didn't follow the procedures laid out in the Constitution when it comes to subpoenaing an individual citizen, let's say, in a proper manner that allows for due process to be effective.
Right. Well, so then arguably, okay, so let's assume everybody's right. Let's assume everybody's wrong, right? So Merriman's attorney didn't go through the right processes to get the order he wanted. The Chief Justice didn't follow the rules to do what he wanted. Lincoln certainly didn't follow the rules of the Constitution to get the legislature to pass the law. By the way, Congress was out of session at this time, so Lincoln decided it would take about a month at that time to bring Congress back. So he just decided, I'm going to issue this order on my own. So let's assume everybody's wrong, right? There's enough taint to go around on everybody. What does that mean for the denial of Merriman's rights? Should the judge just let the rights be violated and not issue the order?
No, not at all.
Why?
Well, from my understanding of the Constitution of Article 2, it seems to be that the Supreme Court justice short-circuited the entire process laid down by the Constitution And given the matter that it was issued on an ex parte basis, I mean, it's like he short circuited everything without the proper notification to both his attorney as well as Merriman, and without even input from the Congress itself, which was out of session. It's like he went around the entire process laid out for him directly to get Merriman into his office.
Right.
And this is not the correct way of doing it. I mean, we don't do that today, do we?
Well, we're going to talk about some cases where there's some shenanigans have gone on. Let me ask this question. This is the hypothetical I love to present people. What if Merriman was scheduled to be hung at the fort? Would it matter then if the judge went around the process and issued an ex parte order?
He still would not have received due process, have a hearing.
No, I understand that, but so ex parte is kind of like a question of how much you have to do something right now, right? So the court has authority to short circuit the procedural rules if they think it's really, really important and it's got to be done right now. So the question I have is, if Merriman was going to be executed, would it have been okay if the judge went around the issues of service and due process?
No.
Really? Why not? What about hanging? Can you undo?
It's a good question. I haven't thought about that. Sorry.
We're just here to talk and think about things. I mean, that didn't happen. Interestingly enough, I think someone needs to write a screenplay about this, because in the end of this case, guess what happens to Merriman? He never gets actually charged. He never has a trial. After the war, the political motivations to prosecute all these people go away. So his attorney, who deserves an attorney award, I guess, for dragging this out as long as he could, drags this case out throughout the whole Civil War. And eventually the U.S. Attorney's Office just loses interest in prosecuting Merriman, and he's let go. So sometimes dragging things out is the
well, did they have sufficient evidence to charge him?
Well, we don't know, right?
Yeah, we don't know. Yeah.
We don't know because of what Lincoln and the Justice did. So I'm going to try and read this. If you guys want to, I'll try and read this quote. It's not one of Lincoln's most eloquent quote. It's a very, very powerful quote. I think all of us could have written this shorter, and I think he was very, very frustrated and was trying to put too much into one quote, but he packs a lot into this sentence. So Lincoln basically ignored the writ, and then a bunch of months go by, and then Lincoln finally issues this statement: the whole of the laws which were required to be faithfully executed were being resisted and failing of execution in nearly 1/3 of the states. Must they be allowed to finally fail of execution, even had it been perfectly clear that by the use of the means necessary to their execution, some single law made in such extreme tenderness of the citizen's liberty and practicality, it receives more of the guilty than of the innocent, should to very limited extent be violated. So essentially what he's saying here is, you wanted to destroy the Union just so you could uphold the writ of habeas corpus, right? It's not Lincoln's best moment, and I understand his frustration. The question I have for you guys is, then to compare that, then look at Alexander Hamilton's quote in one of the Federalist Papers, where he says, if we are wise enough to preserve the Union, we may for ages enjoy similar to the insulated situation. So what he's saying there is, if we preserve the Union, we can enjoy the prosperities that we've had. That's not a technical lawyer answer. That's not saying the writ of habeas corpus should be upheld no matter what. That's saying we might have to bend the rules a little bit to preserve the prosperity that we have if we preserve the whole Union. So the question I have is, for the group, is which laws should we bend or allow to be broken so that the whole union can be preserved. Do we get to pick those? Who gets to pick those?
I'd say the legislature, the Congress.
That is a brilliant answer. The legislature is king. If you read the Constitution, the legislature has the authority to pass laws, change the Constitution, and impeach not only members of the judiciary and the executive branch, but its own members. So the legislature is king, and that's probably the best answer I've heard in given this talk. So it's kind of an open question, right? And this is where you get in, this is where you get into the really nitty-gritty facts of a case are really important. So we're going to look at Youngstown and the steelworkers strike and the relative chaos that was going on in the country. How far was the Korean War from Youngstown, Ohio, versus how far is Baltimore, Maryland, and the Union, the Confederate sympathizers from Washington, D.C.? How vulnerable was Lincoln? How vulnerable was the Union? What did Lincoln do? What did Truman do? So these very specific facts come into play, and people want there to be just some kind of like really easy test that says the executive branch of government can do this and they can't do that, but it really doesn't work that way. The very particular facts of case are become very, very important to the analysis by the court. All right, so just a little back to junior or senior year in high school, separation of powers. Everyone probably knows what that is. Executive branch, judicial branch, and the legislative branch have different authorities. Under that question of the executive branch of government, there becomes essentially three tests. I know it doesn't exactly work this way, but it kind of does, and it's falling more and more into this. If you read the recent cases, the last 4 or 5 years from the court, they're using these three tests over and over again. So the default test for whether or not when the executive branch of government does something is called rational basis. And that's just basically if there's authority under the Constitution for the executive branch of government to do something, and there's any kind of basis, any kind of rational basis for them to do what they're doing, the default position is that it's going to be constitutional. So the example I usually give is the Constitution. It says that the executive branch of government has the authority to set up a post office. That says a post office. Doesn't mean you can set up a post office everywhere. But if you go and set up a post office in Pasadena, someone may argue, well, you didn't specifically have that authority under the Constitution. But they use rational basis to say, look, we need to send mail across the whole country. The Constitution allows the executive branch of government to set up a post office. We have to have a post office in all the cities. So there's a basis, there's a rational basis for setting up a post office. Therefore, the default position is it's going to be constitutional unless there's some compelling reason why it's unconstitutional. So the default is it's constitutional. Then you get this intermediate scrutiny, which was a test created by my favorite justice, Justice O'Connor. And this is getting used more and more. Originally, it was created as a test just for the difference in gender issues. And now, if anybody's read the gay rights case that came out 2 weeks ago, this test and the test for gender differences is also being used for sexual orientation. And this test is the position of the government is going to be constitutional if it meets a necessary, important goal and is narrowly tailored to fit that goal. So if there's another way you can do it, but you can narrow it down and make it as least restrictive as possible, then what the government is doing is okay. And then the final test, the test where the government is by default not doing something constitutional, is what's called strict scrutiny. And that means that the act of the government has to be necessary to support a compelling interest and has to be the least restrictive means possible. So for instance, let's look at what Lincoln did. Who thinks that what Lincoln did meets strict scrutiny, meaning there was no other way possible that Lincoln could have did what he did, which means trying to protect the capital of DC from Confederate sympathizers. Is there any other thing Lincoln could have done that would have not obliterated the Constitution as much as he did? So Lincoln has to pass strict scrutiny because he is denying constitutional rights. So it's not a rational basis test because he doesn't have specific authority under the Constitution. It's not an intermediate scrutiny test because we're not making a distinction based on a gender or sexual orientation. So this is a test based on the violation of a fundamental right, whether or not you can be locked up without due process. And the question is there anything else Lincoln could have done that was more narrowly tailored, that was less injurious to the Constitution? And the answer is obviously yes. He could have just given these people hearings.
Yeah.
He didn't have to give them bail. He didn't even have to give them attorneys. He could have given them evidentiary hearings. So there's a lot of things that Lincoln could have done that makes what he did not pass strict scrutiny. So Youngstown case, I would imagine last time I did this talk, there was a bunch of people who were alive and kind of remember this. Does anybody here remember around in 1951, 52, the Korean War and the steelworker strikes in Youngstown, Ohio? It's kind of an interesting time if you're a history buff of union organizers and union labor. This is a big deal. Recently met someone on vacation from Youngstown, Ohio, and we had a good time talking about this case. So another example of executive power, and this is during the Korean War. There's a strike in a factory producing armaments for the war, and what does Truman do? Truman sends in the National Guard, and there's essentially a battle in Youngstown, Ohio. Not a peaceful protest by any stretch of the imagination. It actually is used by union organizers as a rallying cry because of the brutality that the government instituted at that time. So this case goes up whether or not Truman had the authority to send in the National Guard to bust up the union strike. And the court had not created a test yet for whether or not how to apply the levels of review to executive powers. And so they created this test, and this is the test that's used today. When I passed the state bar, when I took the state bar of California, we had a question exactly on a full essay question exactly on executive powers, because I took the bar right after or a few years after 9/11, and when the Patriot Act was being challenged in court. And the test that the Supreme Court comes up with, it's a three-part test. And the first part of the test is that if two branches of government act in conjunction, so if the legislature and the executive branch of government act together, then it's by default constitutional. If one of the branches of government acts against the other branch of government, it's by default unconstitutional. So if the executive branch does something and the legislature tells the executive branch you can't do that, then the default position is that the executive branch of government is wrong and it's unconstitutional. Then there's this gray area where the executive branch of government acts, but Congress is silent. And that's what happened in Youngstown, and that's what happened in ex parte Merriman. So in Youngstown and ex parte Merriman, the executive branch of government, the president, issued executive orders, and Congress didn't do anything. So the question is, does it matter? And the court rules that Truman didn't have the authority to do what he did. So the question is, does it matter that the Korean War was a long ways away from Youngstown, Ohio? Would the facts of the case be different if there was a battle going on, if there was an insurrection in Ohio?
I'm trying to clear up this audio. If you have a comment or question that you would like to make, you can actually just unmute yourself. But otherwise, I'm going to try to keep most people muted so that we don't have some of the feedback that we have now.
No, that's fine. So that's I personally think it does. There was not an extreme threat to the government, although we were in a war. I think that Lincoln's under a much more sympathetic position. I don't know if it would matter to the point of making Truman's actions constitutional. But the second question, the actions of the Southern sympathizers in and around Baltimore, Maryland, right next to Washington, D.C., are certainly different than trying to produce armaments to go fight in Korea. So those are the kind of facts you have to look at on specific issues. You got to get really into the nitty-gritty of facts. So I need to go. I don't know how I got on this, but I got to go to the next screen. There we go. Okay, so Korematsu case. actually where you are in Pasadena. There was a large Japanese American community interned from that area. Where I grew up in the Central Valley, there have been Japanese farmers there since the 1920s, and they were all interned as well. So I learned about this pretty quickly when I was in elementary school and high school. So World War II breaks out, and there are issues of German sympathizers. A lot of people don't know that the executive order.
Mark, hold on just a second. You would like to unmute yourself? I just muted everybody. If you'd like to unmute yourself, then we could bring your audio back. I actually was getting too much feedback from everybody else, so I just muted everybody, which unfortunately muted you as well.
That's fine. I'm unmuted
Perfect.
now. Everybody okay?
Yeah, we're good. Thank you.
All right. We're getting to the home stretch, so hopefully I haven't gone too fast or gone too slow. We just like to make things just about right, and hopefully it's raised some questions that have been interesting for you. So right now what I'm talking about is the Korematsu case. Hopefully everyone knows at least a little bit about this. So the issue was right after World War II broke out, there was a lot of German sympathizers for World War I on the East Coast. And so there was an executive order regarding German citizens on the East Coast and Japanese citizens on the West Coast. The executive orders regarding the German citizens, their property wasn't confiscated, and they were pretty quickly could figure out who the sympathizers for the Nazis were or not. It was a little more difficult on the West Coast, one being spread out, two, the difference in populations, three, there's also some very specific racial issues, and the confiscation of property also became very problematic, and this is a very dark decision in the history of the Supreme Court. It was good law up until only a couple of years ago. And the good law was that the executive branch of government, in the time of threat of war, could lock people up and detain them and take their property, which we'll get to on another question at the very end of this talk regarding the Fifth Amendment, which I find interesting. So one of the defendants, Korematsu, refused to be interned, and he sued the government. And the Supreme Court issued an order. Let's see, I don't know how to, trying to go to the next screen. There we go. So the Supreme Court issued an order upholding the actions of Franklin Delano Roosevelt in the executive order. So one of the questions, and you get into these complicated questions of facts, is what was the difference? Why were the German immigrants detained and released, but the Japanese immigrants not? Does anybody have any ideas on that? So this gets into a complicated question. If you read the case, there's a lot of arguments made. That, you know, basic argument we understand now is this was racially motivated, but they were looking at the problems of interviewing people. They didn't have translators. Some of these Japanese communities were very insular and would not communicate. They didn't have interactions with other people. They were untrusted. Like the German communities, which had been in these areas on the East Coast for a long time, and they had integrated, even though some of these families were sympathizers for the Germans in World War I, they were not now sympathizers in World War II, so they could be questioned and released, as opposed to the Japanese citizens who were detained and all their property taken. So in the decision, it goes into some really, really complicated facts on why it's upholding the detaining of Japanese citizens. And you got to remember that the time frame too, although now it's been overturned, we know it's not constitutional. Early 42, there was Japanese sightings of subs. Pearl Harbor had basically just been decimated. There was Philippines had been taken over. Singapore had been taken over. Mainland of China had been taken over, and there was a big threat that the Japanese were going to invade the West Coast. We know now from reading all the memoirs of the Japanese generals that they weren't really going to do that. They had realized that taking over the West Coast would be far too difficult given the geographic landscape, and specifically cited, interestingly enough, was the Second Amendment and how many guns there were in private possession on the West Coast. So the fear was not realized, but at the time, in early 42, the government and the court thought we got to do something. So that's what the argument was to uphold uphold this decision. And I'm not in favor of the decision. I'm just trying to give you the background on why it was upheld at the time. So the question is, if we look at the Korematsu decision, and we know it's not good law now, but it stood for good law for about 65 years. Under the Korematsu decision, would Lincoln suspending the writ of habeas corpus have been constitutional? Anybody got a response to that? So I'm asking people to look at what Lincoln did in the ex parte case, in the ex parte Merriman case, but apply the rules and the logic of the Korematsu decision. And the answer, I think, is pretty clearly is
Be supportive of the president.
Yeah, the answer is pretty clearly. I think that the threat to Lincoln was worse than the threat to FDR. We know that empirically now. And I think if Korematsu was good law, then ex parte Merriman should have been overturned and been bad law. And ex parte Merriman was not overturned. So the court just kind of let Korematsu stand out there on its own for a long time, and it was quickly not applied, but it was treated as good law, but not really applied as good law. So after Korematsu and after 9/11, we get a string of cases essentially lumped together. It's called the Guantanamo Bay cases. The most specific one is a Hamdan versus Rumsfeld. So right after 9/11, and then in 2003, there was battles in Iraq and Afghanistan, and some U.S. citizens are picked up as enemy combatants, and they're taken to base on Guantanamo Bay, and they're not given any rights. The lawyers challenge the actions of the government under the writ of habeas corpus to have their clients brought to the United States and have military or civil trials or criminal trials, to have right to a counsel, and they're denied. So these cases go up through the Supreme Court. The decision in the Hamdan case is you need an abacus to actually understand it. It's the problem of multi-party decisions. What I mean by that is every justice in the Hamdan case wrote their own opinion, so you have to read all of the opinions and kind of create a scoreboard to figure out what the majority rule was. They didn't sign on to each other's logic. They signed on to some of the conclusions, but they didn't sign on to each other's logic. What you can deduce from reading the case is that the court said any U.S. citizen cannot be detained indefinitely by the federal government, by the executive branch of government. So the question is, does it matter for our purposes of understanding ex parte Merriman what ground the person was detained in? So what I mean by that is it's not a question of U.S. citizen. Merriman was a U.S. citizen, and Hamdan was a U.S. citizen. The difference between the two, there's a lot of differences, but one of the differences is Hamdan was arrested, essentially, as an enemy combatant on foreign soil and taken to, arguably, and I say that arguably, foreign soil on Guantanamo Bay. So the question is, do those facts matter? Does it matter where the person was detained and where they were taken? Meaning, does it matter that nobody in this was ever technically on U.S. soil?
Yes, it would matter because the court didn't have jurisdiction over the man.
Very good. That's the assessment, and the Hamdan case says no. They finally ruled no. If you detain a U.S. citizen, no matter what, you have to give them the right of habeas corpus. So you've got to give them a trial. You got to give them an attorney. All those rights kick in. But your assessment of the question is exactly right. That's why Guantanamo Bay was chosen to house the people and to interrogate them, because it was not on U.S. soil, and they thought they could avoid the plans. Interestingly enough, my criminal law professor in law school was tasked with setting up a court system about 3 days after 9/11. They asked him, he was a U.S. attorney at the time, and asked him, or sorry, he was a JAG attorney, and they asked him to set up a court, and his plan was Guam, and because there was basically a closed base, a big court system there, they could house everybody, it's secure. but he was shot down specifically because they told him because it's U.S. soil and we're going to fight the writ of habeas corpus. So he was promptly escorted out of the JAG after that and became a professor.
When he had
So
been subjected-
go ahead.
Would he have been subjected to military court proceedings in any way, shape, or form since the JAG officer you mentioned would have duly taken him to Guam?
I'm
wasn't
sorry,
in the military.
I missed like 90% of that question, but I think you're asking, was he? What if he was in the position of the general of the fort base? Could he deny the orders of the president?
Yeah.
Yeah, it's a good question. I mean, that's why he left the JAG. Was he didn't agree with what was going on in the prosecution of the enemy combatants at that time. So that's one of the honorable things to do if you disagree with something as being immoral or unethical, is to drop the case. It's always acceptable for the attorney when your client asks you to do something unethical to say, I can no longer represent you. So that's what a lot of people did in the JAG at that time who disagreed with what the government was doing. So the second question I have on this is, does it matter what Lincoln's doing, where he's doing it? So for instance, as Sherman was moving through the South and detaining enemy combatants, arguably enemy combatants, can he deny them the writ of habeas corpus? Is that different than Lincoln doing it in Baltimore when people are living their lives and trying to grow crops and do commerce? Does it matter the land that someone's on? Because arguably, Georgia had seceded, it's foreign soil at that time, and when Sherman gets down there, can he arrest and detain enemy combatants without due process? Maybe. Under the Hamden case, we'd have to say no, right? Even though they're saying they're not U.S. citizens, we know they're U.S. citizens, and they're going to have rights. So
that has been ceased.
So the last actual case we're going to review tonight, and I thank you so much for your time and listening to me, and all your questions have been great, is that this is the Trump travel ban case, and this case actually overturns Korematsu. So Justice Roberts in the Trump travel ban case takes his time to stop and say, the court has avoided the question of Korematsu for years. We are now officially overturning Korematsu. So Korematsu is no longer good law. And interestingly enough, the case that overturns Korematsu is the Trump travel ban case. So what happened in the Trump travel ban case is the aftermath of 9/11, and there's rising fears of terrorists coming into the United States from certain countries. 3 different iterations of the travel ban are issued by President Trump, and the first one is the one that comes up through the court. So a lot of people, you got to keep which version of the travel ban you're talking about. The court ends up upholding the third version of the travel ban, but this case is decided on the first version of the travel ban that comes up through, and it's interesting not only because it overturns Korematsu, but the interesting sub issue, which we're going to connect back to Lincoln's comments and maybe the subjective motivations of the Chief Justice in issuing the ex parte Merriman case, is Trump issues a bunch of tweets about his Muslim travel ban, not a ban on specific countries for specific reasons, but he issues tweets about his ban on Muslims coming into the country. So the question I have for you is, do the subjective motivations or the comments of the executive branch on an executive order, do those determine whether or not something is constitutional, and should they? Kind of a hard question, because people want to say that it should for some presidents but not for others, and the court doesn't really look at things that way. It's got to be a rule that's got to apply to all the presidents equally. And so Lincoln didn't really care. If you read his comment, it's pretty terse. He talks about this little right of writ of habeas corpus not being very important compared to all the other rights, and I would argue that the writ of habeas corpus is one of the fundamental basic rights of of due process of law and the rule of law, and Lincoln just kind of ignored it. So Lincoln had some subjective mindsets that maybe make his ruling questionable. Trump certainly had some comments that make his motivations questionable. I don't know. I personally don't think that the subjective comments of the executive branch of government matter. I think that what's on paper, what the law does, what the executive order does, and whether or not the Constitution says they have the authority to do that is the most important thing. But you can also see instances where the subjective comments of a president might be so offensive or indicate such animus that they would matter. I'm not sure in this case if that's the rule you want, that every time a president makes an offhanded comment that we're now going to not allow the president to have the authority to do that, because you got to remember it's going to work not only for Trump, but it's going to work for the next president and the next president after that and the next president after that. So whatever rule the Supreme Court puts in is going to be applied based on the concept of stare decisis until it's overturned. So with that, it becomes questionable, I think, whether or not we want to apply the subjective comments of a president as to whether or not their executive orders are constitutional or not.
Mark,
go ahead.
In the Maryland case that Lincoln was involved in, Congress was missing in action.
Right.
And in the last, I don't know, 3-4 years, Congress basically has been missing in action when it comes to the issue of what to do about immigration issues such as this.
Right.
Barring particular countries or population of people from immigrating into this country. Where's Congress on all this? Who are supposed to make the laws or advise the laws that need to meet the constitutional strictures that are given, instead of relying upon executive orders from the president, as has been the case in both issues, both situations.
AJ, you bring up a fantastic comment, and I know you guys are a Civil War group, but I recommend this book. I wish I could buy like thousands of copies and just hand them out. There is a book called Plain Honest Men that attempts to make a transcript of the debate of the framing of the Constitution. So no one was there making a transcript of the oral arguments. So this is not the Federalist Papers. This is the oral arguments during the day for the few months that they were all in Philadelphia arguing over the Constitution. And in that book, there's a really good discussion on the issue of immigration, and specifically the question that they left it out. The Constitution is essentially silent on what branch of government has the authority over immigration. Now, the executive branch of government obviously has authority over control of the borders, but the court has said control of the borders, meaning ports of entry, is not necessarily control of immigration. So the question for you in the panel is, why would the framers of the Constitution have left the issue of who controls immigration out?
If you want to respond, you can just press unmute on your on your computer.
Yeah, if anybody wants to respond. So the question before the panel is, why would the framers have left who has control of immigration out of the Constitution?
I think at the time that the founding fathers had put the Constitution together, and shortly before that, the Articles of Confederation, immigration in this country was not necessarily an issue per se. They pretty much welcomed anybody who came in, of whom were mostly Europeans.
Right. So I think you're partially right, but the discussions were partially that they didn't want a lot of blocks because they wanted more people. That's true. But the other thing was all of these states wanted to control their own immigration, right? So they wanted to control who got to come in, who didn't, because they all wanted to increase their populations. So they made a decision to kind of like, we can't make a compromise like they made all these other weird compromises. We can't make a compromise because with immigration, it's got to either be one or the other. And if you look at the issues of Brexit, this is the one of the main sticking points of Brexit was immigration and the flow of information, goods and services and people between the free zone in Europe and the broken off zone in England and Great Britain. So the states wanted to control their own immigration, so that's why they just kind of left it silent. So right now there's kind of a split of authority, whether or not it's under the executive branch of government, under the right to control the borders, versus part of the court wants it to be under the Commerce Clause, and if it's under the Commerce Clause, then it's squarely under the legislative authority.
I have a question, Mark.
Sure.
You mentioned the book Plain Honest Men. Who's the author?
You know what? I'm horrible with names. I can look it up real quick and tell you if you give me a second. It's a fantastic book. Give me 1 second. I'll look it up for you. And what it is
Richard Beeman.
Yeah, that's it. So what he does is, so all of the guys, they're all just all guys, they're men, at the Constitutional Convention, they go home and every night they write to their friends, they write to their wives, they write to each other. And so like one of them will write a letter to his wife. Today, Benjamin Franklin argued for a unicameral system. And so this guy takes all of the letters from all the different members of the people at the Constitutional Convention, and he takes all their letters and puts them together in a timeline and tries to put together a transcript of their oral arguments. And it's very interesting because even though I love the Federalist Papers are obviously skewed towards one perspective. This is essentially trying to get, you see that they were actually thinking about stuff. They're throwing up ideas and they realize that wouldn't work, so then they abandon that idea. So it's an interesting case. So
Mark, just a quick FYI for everybody, I posted a link in the chat window for an Amazon link to the Plain Honest Men, if they want to just take a look at it there. It's available for $14.90, basically $15.
Yeah, it's a great book.
Oh, Roy, doesn't matter.
Well, I want to know who the publisher is. And,
I think that's about it. I've got one more hypothetical that is not. It's going to sound like I'm getting into something but you guys seem like a really good group, so it's going to sound like I'm getting into something that's very controversial. But hopefully, if the example I can give, it will dissipate that thought. So we've had a lot of use of executive power in the last 3 or 4 months with this the COVID outbreak, right? And then we've had a lot of demonstrations with all of the issues regarding police authority, Black Lives Matter, and so I think that these issues regarding executive power, police power of the government, note that the Constitution does not have any general police authority, which is why we spend so much time arguing over where in the Constitution either branch of government has the authority to do something. I'd like to present this as a hypothetical question to the group. So let's make up a hypothetical. Let's say there's a 40-year-old woman who runs a hair salon, and she's ordered to shut down her hair salon, and she would have made $5,000 in profits in the month of March, but makes zero because her shop is shut down by executive order. The Fifth Amendment of the Constitution, the Takings Clause, says the federal government or the government cannot take property from a citizen unless it is for a public purpose and they pay just compensation. So my question to the group is, given all of the shutdown of all the businesses, is the government on the hook to pay everyone their profits they would have made?
I would say so.
Why?
Well, the COVID-19 pandemic we've been experiencing, it's an issue that probably could be more directly a case of state statute, but I don't know how the state statutes are organized in that regard. I don't know.
Roy, is it possible for you to move a little closer to the mic? It's very difficult to hear you.
Oh, I'm sorry about that.
That's okay. So I think you're onto something, and it's related to and I'm not trying to throw too many names at you, but there's a case from the early 90s called the Kelo case that really changes the Fifth Amendment, the Takings Clause of the Fifth Amendment. So it used to be that the takings clause was only strictly applied when the government would take property for something the government was actually going to use. So like a freeway or a hospital or a school. The government can
Eminent
take,
domain.
right. the
Eminent
government-
domain?
Correct. It's eminent domain. The government can take your house and build a street, right?
Right.
But the Kelo case changed that, and it said, well, if the government wants to take your property, but they're not going to use it, but they're going to use it for a good purpose. So in the Kelo case, the government wasn't going to use the land, but they were going to build a resort that was going to build up the tax basis. So then the Supreme Court, and this is a very controversial decision, rules in the Kelo case that public purpose can be for a public use. So the government doesn't have to actually use it, but as long as it supports an interesting or an important government purpose. So that to me falls into shutting down the government. I don't think people are going to argue too much that it wasn't an important government purpose because of the outbreak. But people could argue, well, the government wasn't using your property, so we didn't actually take it. But if that taking was for a public purpose, under the rule of the Kelo case, I think people have a decent argument that the government has to pay them their profits that they would have made.
Well, back in the end of the 1960s, I was living in Westchester at the time, which is next to LAX. About 3,600 homes were taken on the assumption by the federal government that those homes were underneath the clear zone that was necessary for the two airstrips built to the north of the airport. And yet they turned around eventually and started building hotels on the same
Right.
damn property.
Right. Well, you guys are fantastic. My contact information's out there. Call me anytime. I would love to come when you guys start meeting and I can actually have an adult beverage with y'all. I'd love to do that. So
Thank you, Mark.
contact me anytime. I love you all. Be safe and read more.
Oh, yes.
You recommended the book. We'll see if we can get it.
All right. Thank you.
Thank
Thanks,
you.
Mark. That was pretty good.
That was excellent. Yeah.